Hi, I'm Lucy Reed. I'm a family barrister and mediator, and I've made this video for people who are going through a family court case but who don't have a lawyer to explain things to them. The video is mainly prepared for parents involved in disputes about their children, but should also be helpful if you're involved in another kind of family court case, for example, about your finances after separation. As a family barrister, I'm in court most days dealing with this kind of case. And I know that coming to court, particularly when you don't have a lawyer, and particularly for the first time, can be a very stressful and confusing experience. I remember the nerves I had when I first started as a lawyer and had to speak in court, and I have first-hand experience of the stress involved in representing myself. I meet litigants in person every day who are finding things very stressful, and I'd like to help make it a bit easier. Of course, this video isn't legal advice, but I hope it will be helpful. Although you'll probably still be nervous about what will happen with your case, it might help a little if I talk through some of the practical stuff, so you have less to worry about and can focus upon saying what you want to say to the judge. In this video, I'm going to focus on preparing for your first court hearing. Some of the things I'm going to talk about might seem obvious to you, but they are things that often catch people out and which can distract them from the really important stuff. I'm going to show you around my local court in Bristol so you can get a feel for what it might be like in yours. Obviously not all courts are the same, and luckily for me, Bristol Civil Justice Centre is a new court building which is quite well equipped, but it should give you a rough idea. Unfortunately, some courts are not purpose-built, so it can be difficult to find a private space to sit in, and the facilities can be variable. Make sure that you know where the court is before the day of the hearing. People often make the mistake of going to the magistrates or the Crown Court because they recognise it from the news. The family court may be within the same building as either the Magistrates' Court, the Crown Court or the County Court. You need to check. In Bristol, the Civil Justice Centre combines a number of different courts, but is separate from the Crown Court. Check the address on the court order, because some courts use more than one location, and so the venue can change from one hearing to the next. If you come by taxi, the driver will need to know which court you're heading to. If you aren't specific, they may drop you at the wrong one. The Justice website, that's www.justice.gov.uk, has a court finder on the homepage. You can find a map of the court using this tool and find out if the court has parking. You can also check what disabled facilities the court has, like ramps and hearing loops. Not all courts have dedicated parking, and some are difficult to get to using public transport, so do make a plan before the morning of the hearing. Leave plenty of time to allow for traffic, delayed buses or trains, or just for getting lost. Better to arrive early and calm than late and hot and bothered. I always work out which train I need to catch to arrive on time, and then I catch the one before that. It means I usually get to stroll to court rather than arrive in a fluster, so I'm in a better frame of mind to start the hearing. If you're driving, bring plenty of change with you, enough to park all day just in case. If the court is in an unfamiliar part of town, you can always visit the court before the court hearing. It's open to the public, so you can familiarise yourself with the building in advance and may even be able to sit in on certain types of court hearings. Although you should check with court staff before going into a hearing room, as family cases are usually in private. It's a good idea to arrive at court at least half an hour before the hearing is due to start. In fact, the court order will probably tell you to do this anyway. This is so that you can make sure you're ready and discuss things with the other person involved in the case or their lawyer, and sometimes to give you a chance to speak to the CAFCASS officer. I talk a bit more about CAFCASS in the next video, but you can find out about them on their website, which is www.cafcass.gov.uk. That's cafcass.gov.uk. You'll need to go through security to get into court. We're not allowed to film the security process, but usually you'll need to empty your bag, allow your pockets to be searched, and go through a security arch, a bit like security at the airport. Some courts will confiscate anything sharp or that they think might be capable of being used as a weapon. This is standard practice. It's a good idea to put your coins in a purse and your bits and bobs in a bag so that you don't have to spend ages getting through security. I find that there are a few really useful items to have in my bag when I come to court. I always have several spare pens, a highlighter and some post-it notes, a bottle of water, a packet of tissues, my phone and some change. If you get flaky mid-morning, like I do, then you may want to bring a snack or a banana with you. Remember to bring your court papers, and if there isn't a bundle with an index, try and put them in some kind of sensible order in a file so you can find the right document when you need it. Once you're inside the building, you need to find a court list or a member of court staff to point you in the right direction. There may be different waiting areas for different types of cases. The court lists for family cases often don't show the names of the parties, so make sure you bring your case number with you, so you can find out which courtroom your case is being heard in. The most recent court order will have the case number, the date and time of the hearing, and the court address on it. The court usher will often, but not always, be dressed in a black gown, or there may be a counter that you can ask at. If you're unsure, find somebody wearing a suit, as they're probably a lawyer and can point you in the right direction. If you're planning to show documents to the judge that other people in the case haven't seen, you should bring copies for the judge and the other people involved in the case and hand them in to the court usher when you arrive. Everybody is entitled to see everything that the judge sees. Once you've signed in, you'll be asked to wait until your case is called. You may find that your case takes a while to be called because several cases will be listed at the same time slot. In some courts, you'll be able to use a private room, but if it's busy, you may have to wait in the main waiting area. If you're intimidated by the other person involved in the case, ask the court staff. They may be able to find somewhere more private for you to wait. Whilst waiting, you may be approached by a lawyer representing the other person in the case. Don't be concerned about this. The judge will expect you to have a chat with them to see if you can agree on any areas and to identify what the likely areas of dispute are. You don't have to agree anything with them if you don't feel comfortable, but by having a chat with the lawyer for the other person and listening to what they have to say, you will probably have a better understanding of what they're going to ask the judge to do when you do go into court, and you'll have a few minutes to think it through before the hearing starts, rather than being surprised when you go in. I'll talk a bit more about why this can be helpful in the next video. The court order might say that your case is listed for a particular type of hearing and might give you a time estimate. Cases often overrun though, so do make sure that you make arrangements for childcare and parking and time off work on the basis that you might be stuck at court for the whole day, even if the time estimate on the court order is much less. That way you won't be worrying about parking tickets and school runs and can just focus on the hearing. If you have special dietary requirements, bring a snack with you. Some courts have a cafe, others have a snack machine, and some have neither. And not every court is within easy reach of a sandwich shop. If you do have to get away by a certain time, make sure to tell the court staff and the others involved in the case at the first opportunity and ask for the judge to be made aware. They may be able to try and prioritise your case. Don't bring the kids to court with you unless the court has asked you to do so. You will almost certainly not be able to bring them into court unless it's a very small baby and there's no alternative. Family cases aren't open to the public, and although the press are allowed into the hearing, they rarely come and can be excluded if appropriate. If you've brought a friend with you to court, they may be able to come into the hearing and sit quietly and support you, but not speak on your behalf. Someone who does this is called a Mackenzie friend. You should tell the usher when you arrive that you have a friend that you'd like to bring into court with you, and you may have to ask the judge to approve this before the hearing begins. As long as your friend is sensible and doesn't disrupt the hearing, they will usually be allowed in. You must be sure that your friend understands that all the court documents and everything that's said in court are confidential and mustn't be passed on to anyone else. Some judges will ask your friend to provide a short CV or fill in a simple application form. It follows that if your ex wants to have a Mackenzie friend with them in court, they will probably be allowed as well, unless there's a good reason. If you object, you must say so. Tell the usher before you go into court or tell the judge at the start of the hearing. It's generally better not to bring your new partner or someone who's taken sides in the split with you to act as your Mackenzie friend. It will make the atmosphere more difficult and they may not be permitted to come into court, which would leave you on your own. This is an argument that's really best to avoid. Some courts have local organisations that provide support, advice or representation for free. The court staff or your local Citizens Advice Bureau may be able to give you more information about services or schemes in your court or area. There are also national organisations like the Bar Pro Bono Unit that might be able to find you representation, but unfortunately there are no guarantees they can help. Look out for leaflets around the court. In the next video, I'm going to tell you a bit more about the hearing itself, and I'm going to show you what a courtroom looks like. In order to make this film, we've had to get special permission from the court service, and we're not allowed to film people involved in real cases. You should never record your court case unless the judge has given you permission. In these videos, we've used our volunteers to show a scenario involving a male litigant in person and his Mackenzie friend, and a female litigant and her lawyer. Of course, in your case, it may be the other way around. There may be no lawyers at all, or you may both have a Mackenzie friend. Hi, I'm Lucy Reed. I'm a family barrister and mediator, and I've made this video for people who are going through a family court case but who don't have a lawyer to explain things to them. The video is mainly prepared for parents involved in disputes about their children, but should also be helpful if you're involved in another kind of family court case, for example, about your finances after separation. As a family barrister, I'm in court most days dealing with this kind of case. And I know that coming to court, particularly when you don't have a lawyer, and particularly for the first time, can be a very stressful and confusing experience. I remember the nerves I had when I first started as a lawyer and had to speak in court, and I have first-hand experience of the stress involved in representing myself. I meet litigants in person every day who are finding things very stressful, and I'd like to help make it a bit easier. Of course, this video isn't legal advice, but I hope it will be helpful. Although you'll probably still be nervous about what will happen with your case, it might help a little if I talk through some of the practical stuff, so you have less to worry about and can focus upon saying what you want to say to the judge. This is the second of 3 videos that I've made, and so it might make more sense if you've already watched the first video. In the last video, I talked about getting ready to come to court and what might happen before the hearing, but we didn't look inside the courtroom. In this video, I'm going to focus on what might happen at the first court hearing, and I'm going to show you what the courtroom might look like. The courtrooms here in Bristol won't be exactly like the courts in other areas, but it should give you a rough idea, so let's take a look. And before we go, don't forget to turn off your phone. Your case might be in front of a district judge. In Bristol, the district judges use a small courtroom like this one, and the judge will be in a slightly raised position. Usually, if you don't have a lawyer, you'll be invited to sit along the front row with your Mackenzie friend if you have one, and along from the other party and their lawyer if they have one. A party who's represented by a lawyer may sit next to their lawyer, or sometimes will be asked to sit directly behind them. And as you can see, in the family court, neither the judge nor the lawyers wear wigs or gowns. Every court will have a witness box. In modern courts, this is usually a small table like this one, rather than an enclosed box. Sometimes the judge will have a court clerk in court with him. They'll usually be sitting doing some administrative work quietly whilst the case continues, and they'll sit here. If your case is about children, and this is the first hearing, you may find that there is a CAFCASS officer in court with you, and this person might have had a brief chat with you when you first arrived at court. They may try to help both of you to find an agreed way forwards before the hearing, or the judge may send you out to have a chat with them. Usually they'll see both of you separately. CAFCASS stands for Children and Families Court Advisory and Support Service. CAFCASS is an independent agency which provides guidance to the court in cases about children, and CAFCASS officers are trained social workers. Each court has a slightly different scheme, but it usually involves some contact from CAFCASS before the first hearing by telephone and at the first hearing. Shortly before or at the first hearing, the CAFCASS officer may give you a copy of a letter telling you what the results of their safeguarding inquiries have been and what they think should happen next. Not all courts are laid out the same as the ones that I'm showing you. In many courts, district judges will hear cases in chambers, which just means their office, and there'll be a horseshoe arrangement of tables which everyone will sit round, with the judge at his own desk at the top. It might look something like this. Your case might be heard by 2 or 3 family magistrates rather than by a judge. A family magistrate is a volunteer from the local community who makes decisions on family cases with the assistance of a legal advisor. Although family magistrates aren't legally qualified, they're usually quite experienced in dealing with family cases. They'll often sit in a courtroom like this one, with the legal advisor sitting in front of them. Sometimes cases are heard in larger courtrooms than the ones I've shown you, but the procedure and the process will be very similar, even if the design isn't so modern. People often worry about what to call district judges or magistrates. In fact, magistrates are just referred to as Sir or Madam, although people often say, Your Worships, this isn't strictly necessary. And district judges are also referred to as Sir or Madam. Your judge will probably be a district judge. If, though, your judge is a circuit judge, you should call them Your Honour. The court list outside court will probably say what sort of judge is hearing your case, and if it is a circuit judge, it will say His or Her Honour on that list. Ask the court staff or even the judge if you're not sure about this, but try not to worry too much about it. As long as you don't call anyone a rude name, nobody will be terribly offended. People also worry about what to wear to court. Again, try not to get too worried about this. We aren't allowed to film at court on a weekday, which is why this waiting area is so empty. But if we could, you would see a real variety of clothing. Wear something you feel comfortable in, and that's not going to be a distraction either to you or to anyone else. If dressing smart makes you feel confident, then dress smart. Most judges will simply expect you to take your hat off in court and won't be at all bothered if you're not wearing a suit. Eating in court isn't permitted, and chewing gum or crunching polos probably won't go down too well. Bringing hot or fizzy drinks into court is also not permitted, but there will be water in the courtroom. If you have a medical condition that means you need to pause for a snack or to use the bathroom frequently, let the judge know. Or if it's something that's a bit embarrassing, pass a message through the court staff. If there are other practical issues arising from a disability, do let the court know so that adjustments can be made. For example, if you have a hearing impairment, you may need to ask the court to switch on the hearing loop, or you may just need to position yourself in a particular location in the courtroom so that you can hear properly. You'll usually be expected to stand when the judge comes into the room and when he goes out, although he may be already sat down when you come into the courtroom. If your case is in front of a district judge or before the magistrates, you can usually sit down for the rest of the hearing. But if your case is in front of a more senior judge, you may be expected to stand while you're talking to the judge. If this is the case, though, you'll be told, and if you're at all unsure, just ask the judge. Let's look at what kind of hearing you're coming to. If the court order says directions or has a time estimate of something like 30 minutes or an hour, the court will probably be focusing on finding out about the case and getting the case ready for making a decision, but it's unlikely that any major or permanent decisions will be made on that day unless they are agreed. Don't forget that you won't necessarily be finished 30 minutes or an hour after the time the hearing is listed. The first court hearing you go to in most cases will be one of these short hearings. So although everything can be sorted out at the first hearing, if everything's agreed, you shouldn't necessarily expect everything to be sorted out in one day. Don't be too worried if you don't have an opportunity to say everything you want to about the case. The judge at a directions hearing will just need to understand an outline of what your position is and why, so that he can make a plan to get the case ready for a decision on another day. Remember to bring all the court papers to court with you so that you can follow what's being said and correct any errors. In the first video, I talked about how it can sometimes be helpful to speak to the lawyer for the other side before you go into court, even if all you achieve is to establish that you really don't agree about anything. You'll probably come away from a discussion with the lawyer with a better idea of what they're likely to say in court and a clearer idea of the things you need to think about and to focus on when you're speaking to the judge. You can also make sure that they have all your documents and that you have all of theirs, which should avoid surprises or delays. All lawyers have a duty to assist the court, so whilst they can't give you advice about the case and they have a duty to their own client, they mustn't mislead you either. As part of their duty to assist the court, the judge will expect them to try and agree things with you before the hearing, even if you're only able to agree about what you disagree about. If when speaking to a lawyer outside court you're asked to agree something and you don't feel comfortable doing so, just say you'd like to hear what the judge says first. It's fine to agree things outside court and then ask the judge to approve your agreement, but if you're unsure, you don't have to sign up to anything. During the hearing, it can be difficult to know what to say and when. And you'll naturally have lots of things that you're desperate to tell the judge. In the course of each hearing, every party will have an opportunity to address the judge, either through their lawyer if they have one, or directly if they don't. Often, if there's a lawyer involved in the case, the judge will ask them to summarise what the dispute is about at the start of the hearing. It's tempting to interrupt them every time they say something you disagree with, but try to avoid interrupting others whilst they're speaking if you can. You will be given a chance to have your say before the end of the hearing. If there's any disagreement about Mackenzie friends, the judge will usually deal with that first. I suggest that before the hearing you make a short list of the things you want to ask the judge to think about or to order at this hearing. As you listen, make a note of important errors or things you want to pick up on so that you're able to raise them when it's your turn to speak. Lists are usually a better way to make sure you cover all the main issues than a script. The judge should make sure that you aren't interrupted when it's your turn, although he might want to ask you some questions to make sure that the information you give him is the information that will actually help. At the end of the hearing, the judge will decide what orders he will make. If it's a first hearing and you haven't managed to agree everything, the judge will make directions. These are orders telling each of you what you need to do to get the case ready for a final decision. The judge should explain those to you as he goes along, but if there are words you don't understand or dates that you don't catch, just ask the judge to repeat or to explain. It's a good idea to take a note of the order as you go along, because you may not get a copy of it to take with you when you leave the hearing, and it can take a few days to come through in the post. You could ask your Mackenzie friend, if you have one, to take a note for you of the dates that you need to do things by and what it is you need to do, and then you can concentrate on the hearing. The judge may ask the lawyer involved in the case to write out a copy of the order before leaving court, and you may be asked to wait whilst this happens. Sometimes the judge will ask the lawyer to type a copy of the order and to send it into the court by email. The lawyer doing this is responsible for producing an order which matches what the judge said he wanted. If you aren't happy with the order the judge has made, it's tempting to try and make improvements to it by disputing the written version. But the judge will expect the order that the lawyer drafts to match what they've said. If you don't think it's an accurate record of the order the judge made, you should say so, but otherwise you are stuck with the order that the judge made, unless, of course, you appeal it. In the next video, I'm going to give you some information about giving evidence and about challenging evidence. In order to make this film, we've had to get special permission from the court service, and we're not allowed to film people involved in real cases. You should never record your court case unless the judge has given you permission. In these videos, we've used our volunteers to show a scenario involving a male litigant in person and his Mackenzie friend, and a female litigant and her lawyer. Of course, in your case, it may be the other way around. There may be no lawyers at all, or you may both have a Mackenzie friend. Hi, I'm Lucy Reed. I'm a family barrister and mediator, and I've made this video for people who are going through a family court case but who don't have a lawyer to explain things to them. The video is mainly prepared for parents involved in disputes about their children, but should also be helpful if you're involved in another kind of family court case, for example, about your finances after separation. As a family barrister, I'm in court most days dealing with this kind of case. And I know that coming to court, particularly when you don't have a lawyer, and particularly for the first time, can be a very stressful and confusing experience. I remember the nerves I had when I first started as a lawyer and had to speak in court, and I have first-hand experience of the stress involved in representing myself. I meet litigants in person every day who are finding things very stressful, and I'd like to help make it a bit easier. Of course, this video isn't legal advice, but I hope it will be helpful. Although you'll probably still be nervous about what will happen with your case, it might help a little if I talk through some of the practical stuff so you have less to worry about and can focus upon saying what you want to say to the judge. This is the third of 3 videos that I've made, so it might make more sense if you've watched the first and the second videos first. In the second video, I told you a little bit about the hearing itself. In this video, I'm going to talk about giving evidence and about challenging the evidence of other people. Not every court hearing will involve the judge hearing evidence. If the parties haven't been able to agree about things and it's clear that the court will have to resolve a dispute about the facts or a significant dispute about what should happen in the future, the judge will probably have to list the case for a hearing with a time estimate that is long enough to cater for the giving of evidence. If your court order says that the hearing is listed for 30 minutes to an hour, the judge is probably not planning on hearing any evidence, although he or she will listen briefly to what each person in the case has to say. Often the evidence will just be from the parties to the case, that's usually you and your ex-partner. But sometimes it will also be needed from other people who've witnessed something happening or from a professional involved in the case, such as a CAFCASS officer or a social worker who's written a report, and occasionally from an expert. The court hears evidence from people so that it can decide whether what they're saying is accurate, so that it can assess the parties generally, and so that it can decide on whether a professional opinion is well-founded or not. The evidence is tested by the parties and the judge asking the witnesses questions, and this is what's called cross-examination. If you give evidence, you'll be asked questions by the judge and by the other person or their lawyer if they have one. The judge will make sure that all of the questions are appropriate. If there are allegations of domestic abuse, the judge may ask questions on your behalf so that you don't have to ask one another questions directly. If your ex is asking you questions directly, try hard not to get involved in an argument with them and just to respond to the questions that they're asking you calmly. While you give evidence, you'll usually be asked to sit at a table or in a witness box like this. Before you begin, you'll be asked to swear an oath on a holy book or to affirm if you're not religious. Affirming just means that you're solemnly promising to tell the truth. When you start to give your evidence, you'll need to confirm your name and address. If you need to keep your address confidential from the other person in the case, you can complete a C8 form at the court instead, asking the court not to disclose your address. All the evidence will be recorded on tape or in the magistrate's court by the legal advisor taking notes. You'll usually have a jug of water and a glass on the table when giving evidence. Don't be afraid to pause and pour yourself a drink if your throat gets dry. Here are a few pointers for when you are giving your evidence. Try to speak up so the judge can hear you, and try to speak slowly enough so that the judge can take a note. Try really hard to listen to the whole question before jumping in with an answer, and try to answer the question that you've been asked rather than using it as an opportunity to make a speech. Try not to assume every question is a trick question. It can make the process longer and more frustrating and can give the judge the wrong impression. Take the question at face value and give an honest answer. If you need a break to go to the loo or you just need a breather, say so. Sometimes the questions are too complicated or unclear. If you don't understand or forgot the question, don't be afraid, say so. Don't get annoyed if a lawyer asks you questions that you don't agree with. That's the point of the process, and they're only doing their job. View these questions as an opportunity for you to explain why you don't agree or why they're wrong. Don't adopt a policy of blanket denial. If a criticism is justified, be prepared to acknowledge that. If you don't accept the evidence that someone has put in their witness statement or their report, you'll need to ask them questions to show the judge why their evidence should be put to one side. And we call this cross-examination. There is no need to be rude. Try to ask questions which show why what the witness is saying can't be right. You can ask them about, for example, why they've said different things at different times. Or if there's something important missing from their witness statement or report, ask them why it's not there. Try to ask focus questions that have a yes or a no answer. For example, asking the witness to agree with something you say is true, rather than asking a big, wide question and letting them ramble off the point. Try to ask simple questions, taking each point separately, rather than great long questions that contain several points all jumbled up together. Don't ask the same question over and over in the hope that you'll get a different answer. You won't. If there's an inaccuracy, politely show the witness the evidence that demonstrates the error and ask them to correct it. The judge may stop you and ask you to rephrase your question or say that your question is not allowed. It's the judge's job to make sure that the questions are appropriate and that they will be helpful and relevant. You don't need to ask questions about things that the witness agrees with you on. You can ask the judge for help if you're struggling to phrase your questions. Remember, the aim is to ask questions, not to argue. The witness doesn't necessarily have to agree with you for you to make your point. Hopefully, some of the tips in this and in the other videos will be helpful to you. Although going to court is stressful, even if you do have a lawyer, a little bit of preparation can make it easier to deal with, and understanding what is likely to happen can take the edge off things. Best of luck. In order to make this film, we've had to get special permission from the court service, and we're not allowed to film people involved in real cases. You should never record your court case unless the judge has given you permission. In these videos, we've used our volunteers to show a scenario involving a male litigant in person and his Mackenzie friend, and a female litigant and her lawyer. Of course, in your case, it may be the other way around. There may be no lawyers at all, or you may both have a Mackenzie friend.